Yes. I just got the study room. It's 217. And, I was looking for what is known as criminal solicitation. Yes. Now, let's say you're sitting there, Sheriff. Yeah. And somebody said, well, I came some more money. Yes. And I don't want you to enforce the laws. Now, that would be criminal solicitation. Now, this family seems to be having a difficult time with the concept of due process. Now, just looking through some of these federal laws, that whoever unlawfully seizes, confines, inveigles, yes, decoys, kidnaps, abducts, or carries away and holds for ransom, or reward, or otherwise any person, except in the case of a minor by the parent thereof. Yes. Now, I got a little upset at the senior center today. I gave you a screen print, yes, of actually how long it's been since I've been able to have my sons, yes. And then I put in PDF the actual laws of the state of Washington. And I'm kind of getting the feeling that this idea of the family. Now, who was it that decided to come the money? Well, see, there's what's known as the parent abducting my sons. Yes. And then there's what's known as the oath, badge, and attorney. Yes. For ransom or reward. Yes. Is refusing to enforce the laws. And that's criminal solicitation. Now, let's just look at it for a second because I thought I should add some additional pictures. Yes. It says, upon receipt of the petition, the court shall order a hearing which shall be held not later than 14 days from the date of the order. The court may schedule a hearing by telephone pursuant to local court rule to reasonably accommodate a disability or in exception circumstances to protect a petitioner for further acts of domestic violence. Yeah. The court shall require assurances of the petitioner's identity before conducting a telephonic hearing, except as provided in RCW 26.50.085 and RCW 26.50.123. Personal service shall be made upon the respondent not less than 5 court days prior to the hearing. Yeah. Now, a few days ago, I talked to you about the necessity of enforcing the laws, not being able to spend time with those documents. At least not less than 5 court days prior to the hearing. Yeah. Now, if timely personal service cannot be made, the court shall set a new hearing date and shall either require additional attempts, yes, at obtaining personal service, or permit service by publication as provided for in 26.50.085, yes, or service by mail. It's one or the other, not both of them right now. Now, the court may issue an ex parte order for protection pending the hearing as provided. Yes. Exhibit B, Jack. There was no actual service to myself. No. No. I was on personal recognizance. I was on probation. Yes. The Guamanian Superior Court had issued a no contact order as a condition of my personal recognizance. Then you had another hearing 14 days later without any attempt of service. Yes. Now, it is very clear in the RCWs, if you look at the second picture, yes, upon notice and after hearing, the court may provide relief as follows. Restrain me from committing acts of domestic violence. That's right. Exclude the respondent from dwelling. Prohibit the respondent from knowing. On the same basis. Right. But there is this idea of the issuing of protection orders, where you issued it for 2 years. Yes, let's go ahead. Without any Now, who is it that's committing the kidnapping today? I would say, yes, that the petitioner committed the first act of kidnapping. Yes. She abducted my sons on July 2nd of 2011. Yes. Today's date is June 28th of 2019. It has been 7 years, yes, 11 months and 26 days, 2,918 days since my sons were taken. Now, I talked to you about forgery, yes, fraud, and felony. And it looks like the sheriff's office right now is now the kidnappers of the 5 minors named. Now, when it is an oath of office, Bill Benedict, when it is a police chief, yes, it is. When it is one of those elected to office, there's a little difference in the actual how the laws are